colleagues, I want traffic.
If he does that, he'll go hungry. Good morning, and thank you very much for joining us.
Good morning, sir, and good morning to my learned friend, the animal rights lawyer, SM for short.
I see, but it's okay. So such an interesting day to have you on the line. The first one is: have you had the opportunity of reading this judgment as delivered by the court?
I've been on the move as usual. Heading towards the eastern part, about of Accra at the moment, and the usual hassle in defense of God and country. So I haven't had a privilege beyond what I have gathered from the media, but I've seen some little bit of pieces of it.
Okay, so then perhaps I will draw your attention to some of the main contentions, most of them raised by the New Patriotic Party. The very first one they talk about is there's no evidence of assignment. So which means even though if it went to me on record, Akontamaini Wontumi say they actually allowed them onto the concession to do reclamation. The court says there's no the people you sent on your concession do not have the necessary documentation to do reclamation. And also the people also insist, the two people involved, Okum and AC, they insist that they were not sent there to do reclamation only. They also had the authority of both Wontumi and Akonta Mining to do mining, which is illegal, because the assignment issue then comes in. Do you need to show documentation that somebody allowed you onto a particular concession for there to be a decision made against you? I don't know what level of what level of importance should we attach to the claim that's been made by the New Patriotic Party?
Just forgive me if my depth of appreciation of the facts and judgment have some kind of doubt.
Yeah.
But I must say, the very time I spotted the charge sheet, that's at the beginning of this, I cringed. I was worried. I've never been a prosecutor. I don't intend to be. I've always been a defense lawyer. I've defended high-profile criminal cases and very successfully. But I was worried because for the first time, then I had to have recourse to the law because I didn't even know that the 2006 Act, the Minerals and Mining Act, had been amended, especially by the Section 3 of the Act 95 in 2019. And so I looked at it again, looked at the facts, the particulars of the offense, and the way the Attorney General and the state prosecutors, drafted I was so worried because things were so tightened. They were so tightened that it would be. Sorry.
Hello?
Can I come in?
Yes. Please do.
So
we are listening to you.
I was saying that the charges were so late that it would be difficult if the evidence is presented on the part of the prosecution for a defense lawyer to get out of this. Now, if you look closely, you see that there were actually only 2 counts of charges because 2 for each of the accused persons, the 3 accused persons, that making it 6 counts. There were actually 2 for each of them and the same offenses. This assignment thing, I think that the defense lawyers dwell so much on the use of the word assignment without looking closely at the what the law provides as having constituted or will be deemed to constitute assignment at law. They were probably taking assignment to mean a deed of assignment as we commonly use in conveyances, in land transactions, which is a formal document, okay, executed between two parties, one called an assignee, an assignor, that is the owner of the property, and an assignee, the one taking the transfer for that matter. And just to come to the conclusions that once the state prosecutors fail to lead evidence of the existence of that deed of assignment or a document that will be properly taken to be a deed of assignment or a transfer of interest in land or land rights to another person, then there is no proof. That is where they got it wrong. In this particular case, the law defines what to constitute assignment in very wide way, that any act of even permitting a right exercisable at law in connection with the concession by anyone other than the person to whom the right was given. In this case, Akunta Mining, and by extension, its owners and directors. That will constitute assignment. In this particular case, the two individuals, together with their workers, I understand 28 or so of them, this Inkum, is it Inkum? And the other.
Okum and AC.
Yes, AC, who were actually working and very smart on the part of the prosecution. These two individuals who could have been charged as well were not, but they collaborated with the prosecution and were used as prosecution witnesses. And their evidence clearly established that they were working on the land. Contrary to the defense position that these individuals were engaged to do a land reclamation after the concessionaire, that is Akunta Mining and its owners, had finished extracting minerals or mining activities, engage these individuals to do a reclamation exercise. I have read portions of the judgment and the evidence as contained in the judgment to the extent that the two individuals, or at least one of them, confirmed that they were even engaged in mining of the unmined portions of the concession.
Yes.
What it means is that Akunta Mining and its owners did not mine the entire concession. A portion was left intact at the time of the purported, although unproven reclamation exercise, were still engaged in mining of the portions and using the proceeds to pay for some that purported reclamation exercise, because they were not an engagement or how the two individuals were paid for that exercise, to the extent that they will have to have recourse to mining of the unmined portions of the concession to defray the cost of the so-called reclamation, establish that mining was still going on. And that was what led to the second count of charge of knowingly facilitating mining operations without license. So the charges were carefully drafted in such a way that I see that to be a master stroke, part of those who drafted the charge sheets. If I were one of the um, defense lawyers, I should be worried.
I see. So if you were the one defending Chairman Wontumi, immediately you saw the charges, you would have had because you said your opinion was that then you have, even looking at the charges, you had a Herculean task.
Yes, you know, unlike before. In fact, this case, this judgment is a novelty on the basis of the amendment to the 2006 Act. By the 2019 Act, the amendment has tightened up things in such a way that anyone with concession must be worried. You know, before then, these individuals, the 28 or so people or persons that were arrested initially by task force would have been those that the prosecution will parade before court and before the cameras and the media in that soup when the arrest was threatened. These were the individuals that were being pursued in those days. But everything has changed now, where persons, normally the big guys, the kingpins, own concessions. And yet you hardly find them being roped in by the law. Oftentimes in this, what do you call it, illegal mining activities, when the task force or the security agencies go there, they don't find the kingpins, they find the ordinary laborers or workers who come and work just for a pittance. And so after this soup, this individual ordinarily would have been those that will be caught by the law. But this time round, even when you own a concession and you pretend you are not aware and you allow the concession to be invaded by unknown persons, trespassers, call them trespassers, or even langars, call them Galamsey. You, as the owner of the concession, are duty bound under the law to take steps to abate their actions. Otherwise, you will be caught by them. This is what this judgment is signaling.
Wow. Interesting. So for you, what and you are talking about this law because this was done in 2019. It was the time when the proposal from Gloria Kufu, who was Attorney General then, was for a sentence of 10 to 15 years. The majority at the time then insisted that it should be 15 to 25 years, and they got their way. You are saying at the time what they did, tighten the noose around someone like Chairman Wontumi. Once you are able to once you read the charges, you knew that based on the existing law, he had a problem. All the state needed to do little work.
Yes. You see, Sena, the few portions of the judgment that I read, I'm telling you that any lawyer defending this action, on the date the charge sheet is handed to the lawyer, must think out of the box. You know, the antecedents of all this, Akunta Mining and Chairman Wontumi are not new to the antecedents to the amendment. Because as far back as 2013, Akunta Mining and Chairman Wontumi and some others were in court and have sued the Attorney General in 2013, in particular, in Secondary High Court. They have sued the Attorney General, the Chief of Defense Staff, the IGP, and one other individual, and I think the Minister of Mines of some state. They were sued because, according to Chairman Wontumi and the Akunta Mining, the anti-illegal mining task force set up by the then government, interministerial task force that was set up around that time in 2013, had invaded a certain concession in Amenfi area where equipment belonging to the company and other such properties were seized. And they found that to amount to trespass and went to court to claim damages and all that. I've cited that judgment as well, and reading through, I saw that the action was dismissed. Now, I believe that at the time, the law, which was the 2006 Act, was the one in existence. And when, in fact, the 2006 Act was passed by the NPP government, who was in power at the time. Unless I'm wrong, I guess I'm right. 206. Yes, I believe that was during the term of the second term of President Kufuor. And they still found out there were loopholes in the law to the extent that only the small fishes were being caught and the big guys were always being left off the hook. They tightened up things in 2019, I think during the time of President Kufuor, setting the term limit of imprisonment, the minimum sentence of 15 years and the maximum up to 25. So the law was just been applied by the court. This judge was constrained. He could not have come below 15 years. And so he had to operate within the law. I've also seen some, there was a preliminary point of law that was taken and the judge had to rule on that, whether or not there's any interpretation issue with respect to Article 19 and all that. That argument was what the defense wanted to refer to or be referred to the Supreme Court for interpretation. And I think that the ruling of the judge was quite erudite on that, the extent that there seemed to be no lack of clarity at all in the provisions was decided by the court, unless otherwise overturned in a subsequent appeal or whatever. So the judgment serves as a guide, a profound judgment that we'll all be reading for a long time to come.
Well, and I'll come to the MPP's suggesting that they'll be appealing that. But there's one other point where what you call a master strategy, a master stroke when it comes to strategy of the men who were found on the concession mining being used as prosecution witnesses. A colleague of yours who's in the MPP, who is also a lawyer, cites that as evidence of the fact that it was Chairman Wontumi that they were interested in. And that is proof that the MPP is right when they see this whole prosecution is political, because if not, those people too should have been prosecuted. What do you say to that?
Do you forget so soon that during the prosecution of Honorable Ametefe and the famous Japa case, the what do you call it? The Attorney General then, even after making Japa an accused person, thought belatedly that they could have dropped the charges against him and used him as a prosecution witness, even belatedly. And all the soliciting and the conversation that ensued, that became famously known as the Japa tape. What was the Attorney General doing at that time? It's a strategy. It's a case management strategy, not only in criminal prosecution, but even in civil cases. You must choose carefully who you want to bring to court. Sometimes you seek the collaboration of others who you could have proceeded against, who assist as witnesses rather than being made parties. After all, who owns the concession? So why do you go after ordinary workers? That used to be the practice in the past, where you see ordinary laborers with what do you call it? Tools. I mean, good uh, tools like shovels and pickers digging. Those are the people that are picked up quickly and brought before court. And most of the time, in the case of foreigners, they are quickly deported. But the actual owners of the minerals or the mining rights, the concessionaires, are left off the hook. So who decides who the Attorney General wants to proceed against? So I don't understand what is being termed political. Akunta Mining and Chairman Wontumi and his company, they have always been known to be involved in mining, whether legal or illegal. And so assuming that Chairman Wontumi had nothing to do with session, it had nothing to do with mining or the facts leading to this man, then someone can say that it's politically motivated. He never denied the activities of this person. He sought to explain that he engaged them to do a reclamation, which reclamation